Hi, good afternoon and welcome to the WYN Legal channel, the channel which provides tips, tactics and strategies to help you through your litigation. My name is Pranav Bhanot and I am the founder and partner at WYN Legal. We're delighted to have you here today, but I'm even more so delighted to be joined by my colleague, Paul Wreth, who is a senior litigator in our team. Today, we're talking about how to craft and draft powerful letters before action. And quite often, these are really, really important letters to potentially kickstart a claim. So without further ado, I'd like to welcome Paul Wreth.
Thanks so much, Pranav.
Who's been an invaluable member of our litigation team for many, many months now. So thank you very much for all your efforts, Paul.
It's been my pleasure.
Over the next 20 minutes, Paul and I are going to discuss how to best craft and draft your letters before action. And it's an instruction that we quite often see. So Paul, in your experience, how often do you see the instruction, please can you help us with our dispute? Could you draft us a letter before action? What kind of instances do you see in your practice?
I mean, it's almost every case. It's not every kind of dispute where you'll need one, but in the vast majority you will. I mean, everything from contractual disputes to professional negligence claims, even debt collecting claims in particular. So several times a month, I would think. And why might you need them? Well, obviously the first point is you're in dispute with somebody over something. You've exhausted all informal approaches. I mean, no doubt, before you are even going to think about a letter before claim, you've tried to speak to your opponent, you've tried to sensibly and civilly resolve matters, but you're simply, for one reason or another, just not getting anywhere. So you really want to then be taking the dispute to the next level. The letter before action might in itself put pressure upon your opponent to start talking sense, to start talking about settling, without having to go to the cost and expense of court proceedings. But of course, it's absolutely essential to have a letter before action in most cases if court proceedings are within your contemplation. That's what you want to do, because the court will want to see it.
Yeah, absolutely. I mean, Paul, just taking it right back to basics. I mean, we hear the word letter before action. Some people call it a letter of claim. For those of our viewers who've heard this name rattled about or tried to put it into ChatGPT, what is a letter before action?
Well, you're about to kick off court proceedings.
Yes.
I want to sue Joe Bloggs, whoever it might happen to be. He owes me money. He's a builder who's done an awful job. He's a customer of a builder who won't pay me. The list is absolutely endless. So what your letter before claim will do is set out, hopefully in a cogent, sensible way, what it is you actually want to achieve in relation to this dispute, how you want to resolve matters, what your claim is all about. And it sets it all out as a preliminary, if you like, to issuing your court proceedings. That's really what it's all about. It's almost perhaps the first time you would have had an opportunity to sit down, reflect on what your dispute is all about, and to put it into some logical format that your opponent and ultimately maybe even a judge will understand. And you need to do it, as I say, before you issue most types of proceedings.
No, and I think that's really sound advice. In your experience, how have you seen letters before action structured? I mean, do you follow a certain structure yourself, or for those of our viewers that are watching and are thinking about drafting a letter before action, does it follow any template in your experience?
Well, there are some basic rules, but they're going to be tailor-made. Let's put it that way. What are you expected to have in there? Well, maybe obvious, but a summary of the facts in a clear and chronological order. I personally, before I sit down anything other than the simplest of letter before actions, is look at all the documents, look at any statements that have been made, look at letters, emails, WhatsApps, any communication, put them into some sort of date order so you can get an idea of what's what. And then fill in the gaps if there are gaps. And I like to do that first of all. And then there's a sort of a format. Obviously, you're going to want to get the formal parts of the letter correct. Gives you a chance to think about, well, who is my opponent?
Yes.
You might have individuals or companies on the other side. Well, if it's a contract claim, who's my contract with? You want to address it to them. You want to get their address right.
Yes.
You want to get their email address right if you're going to send it by email as well. You want a heading as to what the claim is all about. And then you want to get down to the nuts and bolts and structure of what it is. And it's important to have the basis of the claim. It's important, if there is a money claim, to explain what it is you're owed, why you say you're owed the money, and to set out in detail, if there is detail, how you have calculated that
Yes.
sum. It may be a damages claim. Well, why have you suffered those losses, and what precisely are those losses? The other thing you'll also need to do is to refer to any key documents in the case. If it's a contract, your contract. If you've had correspondence relating to the contract, how it might have been broken, refer to it in the letter, but also include that documentation within the letter. That's really very important. And you want to give your opponent a chance to think about what you've said, and you want to give your opponent a reasonable period of time.
Yes.
And that depends, and we may go on to discuss this, that depends on the so-called pre-action protocol that you might be following. So you're going to give a period of time for a reasonable response. That way, you know hopefully where the claim is going, what the defendant says about all of it.
Yes.
I mentioned earlier on sort of informal discussions or communications you may have had. In the course of that, you may have gleaned something from your opponent as to what it is they say about your claim. They don't accept it for whatever reason. In your letter before claim, if that's happened, address those points. Don't shy away from them. Don't think that you treat the letter before action as the very first communication you've ever had. Be realistic. And you ought obviously to be able to answer those points if you consider them to be valid and relevant. If you don't, say so, but address them. And I would say that as well. So in an ideal world, that is what you would be saying. There are there are formal parts to the structure of the letter, and that does depend on pre-action protocols, and you and I will know what those are.
Yes.
But for anybody that doesn't, they're in a sense part of the court's rules. The courts in most claims have what's called civil procedure rules, and it's kind of the court's Bible rule book as to how claims are conducted. And it's been the case for many years now that the court expects a pre-action protocol to be complied with, and there are different protocols depending on the type of claim. There are specialist protocols, for example, in certain debt cases. If you are a business and you're claiming a debt against an individual, there is a specific protocol to follow. Construction claims, housing disrepair, if you're a landlord of commercial premises who's seeking damages for disrepair to those premises, there's another protocol for that. If your case is not covered by a specific protocol, then there is a catch-all direction that the court has, which it would expect you to follow. And the sort of information contained in the sort of general protocol is pretty much as I've said already. Follow that structure, give a period of time, and two other things. Warn the other side what will happen if they don't play ball with the protocol, because once you've served your letter before claim, you would expect your opponent to respond within a reasonable period. If you look at the general protocol, that tends to be 14 days for a very simple case, up to 3 months for something that's very complicated.
So on that, Paul, I mean, that's a really interesting point about how much time you should give. And we've both seen many clients who've wanted to adopt a very aggressive approach and only give, for example, 7 days rather than the 14 days.
Yeah.
In your experience, what constitutes a more complex claim that might render the full 3 months as opposed to perhaps 14 days?
Well, I would say at the top end of the scale, the sort of 3-month claim, if you've got a particularly complicated, let's say, contractual dispute, it's a commercial dispute, it may be to do with, let's say, provisions of goods within your business, for example. There may be loan arrangements, for instance, things which are complicated both factually, maybe things have been going on for a very long time. The contract is a particularly complicated one. The way in which you have calculated your claim for damages, compensation, is complicated. There may be a number of witnesses that the other side might wish to approach informally to get as much information as possible. There may simply be a huge amount of documents involved in the case, which need to be sort of fully reviewed by the other side. So that's the most sort of complicated type of case. Something simpler might be you've bought some goods from a retailer, let's say, they haven't worked out, maybe some decorating work has been done, something like that. It's pretty straightforward. Everyone knows really more or less what the issues are. The claim is a simple one, and 14 days will suffice. I would say if you look at the protocol for debt collection, where you're a business against an individual, it's expected that you would give at least 30 days.
Yes.
And that can be extended as well, particularly if the individual debtor wants to go off and seek payment advice from a specialist. So you have to be a bit flexible with these dates, but as a broad brush, that's the kind of things really you're looking at. One other thing, I said there were two things. The other thing I suppose I would say about letters before claim is this, and it feeds in. For many years now, courts have expected you to try and resolve matters without court proceedings. Court proceedings are thought of by the courts, and this may be slightly ironic because it's the court's business, as a last resort. Really very much in what I would consider my good old days. That wasn't the case. You could send a 7-day letter and didn't comply, right, off we go, we're going to sue. Courts have finite resources, and there's something in that to their policy of wanting you to try to settle claims without troubling the courts if you possibly can. So within your letter of claim, and you'll find this within I think all of the protocols, they'd expect you first of all to remind your opponent of all of that, and to invite them, depending on their response, to consider some alternative means of resolution, ADR, alternative dispute resolution. That might involve face-to-face negotiations, it might involve correspondence, it might even involve a mediator, where an independent, disinterested third party will try to broker a deal between you. So all of those things do have to be considered, and it's important to realise what will happen if you don't comply with the protocols, and a number of things can take place. Courts don't like it if you don't. One of the consequences is if your case eventually goes to trial and judgment obviously is given in one party's favour or another, the court after that considers, well, who should pay the costs?
Yes.
And if you haven't complied with a protocol in some sensible material way without good reason, the court may penalise you. So if you win the case in the normal course of events, the court would award you most of your costs against the other side. But if you haven't complied with the protocol, then the court has power, it's discretionary, but the court has power and uses it to reduce the costs that you might otherwise be entitled to. The other thing the court might do in, I would say, exceptional cases, in my experience, I'm not sure I could point to a case where it really has happened, is that if you haven't complied with the protocol and you start proceedings, it's open to your opponent to make an application to the court to say, well, this is all premature. We'd like the court to put a hold on these proceedings whilst we do investigate matters. So, you may find that you've spent an enormous amount of costs in getting the case in order for proceedings to be issued, to pay what in some cases is a very high court fee to issue proceedings, to find that money has been wasted because you haven't done your best to get the case resolved.
Yes, I think that's really important. And I had a letter that hit my desk this morning where a client had used ChatGPT, and there was all sorts of legislation, you've breached this legislation or you've breached this legislation. In your experience, how detailed should our viewers go in citing case law or statutory law when drafting a letter before action?
Well, I would say this. I think if you can, you should. If it's relevant. I mean, the vast majority of cases, statute tends not to be altogether relevant, particularly common law, contractual disputes. But sometimes it is. And if you've done your research and you know that your case is at least to some extent reliant on statute, then yes, by all means, I think you should, you could and you should include it. I think that's important. And I have dealt with cases on both sides of the fence, as it were, where if it's an unusual case which is based on statute, I mean, sometimes, for example, you might be pursuing claims in relation to deposits on residential tenancies where landlord hasn't dealt with a deposit properly and the tenant seeks damages as a result. Well, there's a lot of statute law around that.
Yes.
And so if it's relevant, I would say put it in. I think the court wants to see, as I said before, the basis of your claim. And the basis of the claim is really twofold. It's factual, but it's also legal. If there are legal issues, if there is statutory law, if there is case law that you're aware of, then you should certainly put it in. I'm not saying that's relevant to most cases, but I would say in my experience to a fair proportion of cases. If you can, you should.
Yep, no, that's really sound advice. And if we just talk a bit about kind of disclosing of documents, but also requesting of documents that you might like to see.
Yes.
Do you find yourself kind of putting together a list of not just the documents that you intend to disclose or have disclosed,
yes,
but also the sorts of documents that you think you might be able to obtain from the other side?
Yeah, if a client comes to me, with a story and a claim, and it seems that there are gaps, and it goes back in part to this idea of preparing a detailed note, a detailed chronology, and if you're of the view that there are documents missing, I mean, you would expect, maybe in certain contractual disputes, notices of termination might have been served, for example. Well, it's not there. Well, why isn't it there? Well, maybe the client had it but has misplaced it. Maybe it didn't exist in the first place. So ask for the documents if you think they should be there, which would support one side or another's case. Litigation is very much about cards on the table.
Of course.
And the court would not expect you or your opponent to be taken by surprise during proceedings. And sometimes the only way to sensibly negotiate the case is if you know precisely what has happened, as far as you can. I mean, there are going to be times where facts are going to be disputed. I said this, no, you didn't. Are there witnesses and so on? But certainly, certain things in writing, they will be there.
Yes.
And I would say, I suppose, as a tip, it's important not just for letters before claim, but put everything in writing if you possibly can. I mean, it's vital for evidence.
Yes, and I'm sure you would agree that sometimes some of the best wins are those where there's good documents. I mean, cases are won and lost based on the integrity of the documentation.
Well, not only that, but it tends to be a bit easier to give advice.
Yes.
If there's things in black and white, if there are things in writing, because that serves as a much better aid to memory than your memory.
Absolutely. And I think also on that point, I think a letter before action is also a good opportunity to remind the other side or your opponent to retain their documents, not to alter them, not to destroy them. You can imagine a situation where you get an opponent who thinks, oh my goodness, the claim's about to start, let's go and put everything up in the on the barbecue. I mean, it's
absolutely. I mean, and there are cases like, and courts are wise to it. If there are documents that should be there, that obviously should be there and are not, records have been mentioned. Well, where are the records? Well, I don't know. I must have lost them, misplaced them. Oh, I destroyed them because I didn't think they were important. Well, courts are courts are very keen to make sure that parties to litigation, or parties who are even contemplating litigation, are aware of their duty to preserve all documents that are relevant to the issues in the case, whether they help them or not.
Yes.
Which are going to be important to show to a judge to help him or her to come to a decision as to the outcome of the case.
Yeah.
It is vital, and you're correct. It's also important to remind the other side to do exactly the same.
Absolutely. No, that's really sound advice, Paul, and thank you for sharing some of those nuggets. So just to kind of summarise and to conclude, for some of our viewers watching this, what would you say would be the top 3 tips that they should consider before drafting and sending out an LBA, a letter before action?
Well, I would say make sure your language is clear. Set it out in a logical way. Refer to your documents. I mean, that's maybe 3 points in one.
Well, that's a good, yeah, it's a strong one.
But I would do that. I would also say it's easy to become emotional when you're involved in litigation. You know, as I said before, you probably haven't come to a letter before claim in isolation. There's probably been a whole period where you've been arguing with the other side. Don't be emotional when you prepare your letter. I don't think it reads well. Don't insult your opponent. Be clear and calm. It's almost a form of passive aggressiveness, I think. You know, we're looking at this objectively. It's not, you know, it's not just about what we feel thumping the table.
No.
This is what happened. This is why you're in breach of your contract, or why otherwise you might owe us some money, or what the problem is. Because ultimately, what you don't want is to be embarrassed if a judge sits down and reads your letter.
Absolutely. Yeah.
Always. I think my top tip is write the letter as if a judge is going to read it. And then I think it's going to be hard for you to go wrong in terms of the style and tone of the letter. You don't want to be seen as someone who is overly aggressive, because that often denotes weaknesses in your case.
Yes.
You know, be calm.
And confident in the way they portray the case. Yeah, no,
Indeed.
excellent. No, thank you very much, Paul, and that's really, really helpful advice. And if you want to learn anything further about your potential dispute or how we can assist, please visit our website. That's www.wyn, that's WYN.legal. And if Paul and I can assist with any of your matters, whether they're contractual or otherwise, please don't hesitate to contact us. Thank you very much for joining us this afternoon. And please do tune in next Monday for our next episode here